so that the court decided that civil trial proceedings would be open as well. Then let's turn to, that was the NBC subsidiary case. Let's turn to the question of televising executions. And let me take a poll first. How many of you, if an execution were televised, would watch any part of it on television? Honestly, how many of you would tune in and watch any parts of that couple? Really? But let me say, this would be a historic event because there has never been an American execution televised. Not one. Not one. So a few more. Huh? Just watch this historic event. Okay. Are they normally open to the public? Well, that's a whole history that we'll get to in a minute. I want to first get the sense of the crowdsource on the next. If it was a family member, your curiosity doesn't extend that far. Yeah. What type? Well, does it matter? Well, tell me about that. You'd rather watch a hanging than, for example, a firing squad? Yeah. Well, you got a lot of options. Firing squads, I think, are still the law in Utah as an option. Hanging, I think, probably has been abandoned by all American states, but I'm not sure. Lethal gas in the gas chamber may be used still a couple of places, but most states have now gone to lethal injection, where the condemned person is injected with poison that stops the heart and paralyzes the body and kills him within a matter of minutes. So which one of those would you rather watch? Lethal injection? They say it's just like watching somebody go to sleep. It's not exciting in particular. And why do you favor watching lethal injection on television as opposed to the other method? Because you'd be repulsed by what you're watching? That was it? Mm-hmm. No, it's longer than 30 seconds. It varies, but probably figure 5 to 20 minutes, somewhere in that range. Yeah. Well, let me continue with my poll. I get the sense of how many of you would watch, depending on how entertaining the proceeding is. So if instead of being a member of the consuming public, if you were the news director at a television station and you were offered the opportunity to get the proceeding either live or on tape, how many of you would put on the air any part of the execution? Well, and the majority of you would not? Really? This historic event? Never before televised? You can edit it. Still, Dasha? Is the condemned person allowed to what? Well, I mean, the condemned person doesn't have very many rights at this point. I mean, in many cases, including the case we'll talk about in a minute, the arrest was televised, the preliminary hearing was televised, the trial was televised, the appeal was televised, the clemency hearing before the governor was televised. So all stages of the criminal process were televised. And then you get to the culmination of it, and does then the defendant have a right to say, no, this is out of bounds, I have a right of privacy or something? I don't think so. Okay, but it does look like more of you would put on television, inflict on the general public this spectacle, than would choose to watch it yourself. I don't know what that says about you, but well. Right. Okay, last question. How many of you think that the decision about whether an execution should be televised should be made by the government official in charge of the process? The warden runs the execution. The warden presides over the execution. How many of you think that person should be the one making the decision on whether the execution should be televised? Nobody. We're making progress here. We've gotten something across in this course. Great, that's great. Stick to that. All right. I had another KQED case described in the figures book, and it involved access to execution, to televise them. And the case, as I said, there's never been an American execution on television. I've seen a lot of executions on television in Saudi Arabia, Iraq, Iran, China, Cuba. Beheadings, firing squads, hangings. I saw the hanging of Saddam Hussein when they put that up on YouTube. And there have been lots of television executions that are fictional, fake, including some fairly dramatic ones. And there have been a lot of, the greatest, the biggest execution of all time, the crucifixion of Jesus Christ, has been reenacted time and again on television in fairly explicit detail. But our government has never allowed us to see an execution conducted in our name, in any state. Julia? Can we? Yeah, well, forgive me. Let's get to that in a minute. This case started in 1990 when the court set an execution date for a man named Robert Alton Harris, who was a double murderer, whose arrest had been televised, and all the proceedings in his case. And the execution date for Harris was set that year. It would have been the first California execution in a generation. The last one was in 1967, and Harris's execution was set for 1990. And there was tremendous media interest in the case, both in his case, because it was the first, and in the death penalty in general. And during the 1980s, the death penalty was the dominant issue in California politics. It was not possible to run for statewide office unless you were, quote, for the death penalty. 3 justices of the California Supreme Court were removed from office by vote of the electorate because of their perceived reluctance to affirm death penalty judgments, and they were replaced. And so the death penalty was a big political issue at the time the Harris execution was set. All of the media outlets in the state, national and international, wanted to cover the event. And so the warden of San Quentin sent out a media advisory saying that 12 reporters would be permitted to cover the execution at San Quentin, actually be admitted to the death chamber to observe and report on the proceedings. But the warden issued a protocol about how the execution would proceed, and it specified that the reporters at the execution would not be allowed to have cameras or recording equipment or sketch pads or notepads or pencils, nothing. They would be required to cover the execution empty-handed without any of the tools of their trade. Well, at the time, KQED was in the process of doing a documentary about the death penalty. The producer on it was Michael Schwartz, who is still he's not at KQED anymore, but he does a lot of really good documentary work. And he wrote to the warden of San Quentin, who at the time was Daniel Vasquez, and asked the warden whether he could send a camera up to San Quentin to record the execution of Robert Harris. KQED also applied to be one of the reported witnesses at the execution. And the warden promptly and curtly responded, no, there won't be any television, there won't be any cameras, still cameras, notepads, nothing. So Schwartz called me up and he said, can they do that? Allow us to cover the news, but not allowed to use the tools of our trade. And I remembered, I'll never forget, Stewart's opinion in the KQED case that the press should be allowed to do its job effectively, including bring cameras to cover the news event. And it seemed unreasonable, the warden's policy, evicting everybody from San Quentin and from the gas chamber at San Quentin. That's what it looked like in those days. I don't think it looks very different these days. And so we filed suit in federal district court in San Francisco. And the execution of Harris was stayed, was put on hold, postponed, for reasons that had nothing to do with our lawsuit. It was one of those last efforts to save the man's life. The lawyers got a stay of execution for a while, which gave us time to do discovery and to find out what the problem was with televising executions from the warden's perspective. So I went up to San Quentin and took the warden's deposition, and he testified on deposition that his main objection was that televising an execution would expose the guards who work in execution to being identified on television, and that might subject them to retaliation by somebody for having done that. So when we went up to San Quentin and got a court order allowing us to go to San Quentin to examine the death chamber, check out the place for camera angles and so on. Schwartz and our expert witness, Ray Procunier, who used to be the director of the California prison system and had presided himself and was a true believer in the death penalty, but he was our expert witness, and he was willing to testify that there's no security reason for denying television coverage of an execution. So we went up there, scoped it out, got all set for trial, and then 5 days before trial, the warden, by press release, announced a new policy about executions, and that is there would be no press access at all. No reporters allowed at all, not just in the death chamber, but on the grounds of San Quentin. No satellite uplink trucks and none of that stuff. Nobody would be allowed on the grounds of San Quentin to cover the execution. No press access at all. Yeah, I'm glad you're on the case. So what happened was the Attorney General's office, representing the warden, immediately moved to dismiss the case as moot, because you don't have to decide whether you can use cameras in an execution. You can't be there at all. And there's no First Amendment right of access to a maximum security prison. Therefore, the case should be dismissed. Well, what do you need to know in order to resolve that issue? And your question was, if the general public has access to an execution. Why is that important? Under what law? Yeah, something like that. There's no basis for discriminating against the press. If the general public has access, then the press ought to have access as well. So it's important to know whether the general public has access. What else would you want to know? Richmond newspapers. What else do you need to know? The history. The history. Is there a history of openness of execution? Well, when we showed up for trial the judge, who was Robert Schnocke, who was a crusty, curmudgeonly old Republican former prosecutor who had actually prosecuted a writer for sedition in the 1950s during the McCarthy era. Anyway, he says, we try to provide a level playing field here, but it looks like the warden has taken away the playing field. And I begged him to allow us to proceed with our evidence about television and so on, and give us time to develop evidence on the access issue, whether we have a right to be there at all. And he did. He allowed that. And so what we then discovered, doing a bunch of fast historical research, was that all executions in California were conducted in the public squares at the time of the gold rush and into the 1850s. And virtually all Californians had personally observed a hanging, an execution, in their local town square. In 1858, the California legislature enacted a law entitled An Act to Abolish Public Executions. It was based on laws enacted in the eastern United States after the establishment determined that public executions were teaching the wrong lessons to the public. Instead of deterring crime, they were treated as circuses where drunks and disorderly people pickpockets would show up, and they were crime scenes, basically, public execution. And so in these eastern states, they took the execution behind prison walls, no longer conducted in public. But in all of those eastern states, they provided for access by some number of members of the general public to observe the execution. The New York State Senate report said that by allowing a few members of the public there as representatives of the general public, that will provide, quote, ocular evidence, evidence that you can see, that the execution was in fact carried out, that they had the right guy, that it wasn't torture, and so on. California copied that law, and in the 1858 law provided that at least 12 reputable citizens would be required to attend an execution. All of the news reports following 1858 recounted that the executions were conducted in front of hundreds of people. The executions were done by county sheriffs who invited the public into the jail yards to conduct the hangings. And they were all reported by newspaper reporters, so both press and public were there even after so-called public executions had been abolished. And then the next historical event was 1891, where the state took the execution process away from the counties and gave it to the state, which conducted executions at Folsom Prison and at San Quentin Prison. Nothing changed. All of the newspaper reports following that change in the law described the dozens of people who went into the prisons with the warden's permission or request, observed the execution. The reporters were there to write about it, a lot of chilling stories about execution. In 1937, California changed its method of executions. No more hanging. They went to lethal gas, the gas chamber. Nothing changed. When they built the gas chamber at San Quentin, they built it with risers, like a theater, so that the spectators could watch through the glass windows in the gas chamber, could watch the execution take place. And once again, it was well reported. Every execution in the gas chamber was witnessed by members of the public and by reporters who reported about it. So that's where it stood historically. If you're going to apply the Richmond newspaper's analysis, what else do you have to know? What are the functional values, the practical values of openness of an execution? Are there any? What good does it do to have executions open so that people can see them? Okay? Informed opinion. So it sounds to me like you're saying that serves at least two of the values that were identified in the Richmond newspaper: the educative value for the public, look, here's how the system works, and the cathartic value, the therapeutic value to the public of seeing that justice has been done here. These are the consequences of committing a capital crime, providing that release for the public. Right. There's no way to know that jurors will have seen an execution on television. Yeah. Ruby? Done correctly. Well, that's a little bit like the other function.